Welcome to episode 3 of Fair Maps Forward, a podcast brought to you by the Wisconsin Fair Maps Coalition. In this episode, you will hear a pre-recorded conversation between Coalition Organizing Director Yuseli Flores and Doug Poland, who's the Director of Litigation at Law Forward. Doug will talk about updates to Wisconsin's congressional maps, as well as the Callais Decision, which recently came down from the Supreme Court. We hope you enjoy this conversation.
Things I think in particular that Carlene had suggested I might be able to speak about. One is the anti-competitive gerrymandering lawsuit that we brought in the Dane County Circuit Court last year that was recently dismissed by that court and that we've now appealed to the Wisconsin State Supreme Court. And then the other recent case is, of course, the decision by the United States Supreme Court last week in Louisiana versus Calais. That was the Voting Rights Act Section 2 case, the decision that they came out with. Where would you like me to start? I could start with either.
Yeah, let's start with the state, please.
Sure, of course. Okay, so there, as everyone probably knows, and I'm sorry, that's my dog in the background. Hopefully she'll quiet down here. I think as everyone knows, we had tried a decade ago to bring partisan gerrymandering claims in Whitford versus Gill. That was a federal court case. We succeeded in the trial court at that time, the federal court in Madison. We lost in the U.S. Supreme Court. And then the year after the U.S. Supreme Court vacated our win in that case, they decided a case called Rucho versus Common Cause. And in Rucho versus Common Cause, an opinion written by Chief Justice Roberts in 2019, they basically said, boy, partisan gerrymandering is a terrible thing. We think it's a really bad thing. Everybody thinks it's a really bad thing, bad policy, yada, yada, yada. But federal courts it's a political question and federal courts can't touch it. So state legislatures can ban it, state Supreme Courts can ban it, but I'm sorry, we just can't entertain those kinds of cases. And so partisan gerrymandering remained on the table as something that was not banned, at least by state or by federal law, or at least you couldn't bring claim in federal court for it. So we had a couple of different cases in 2021 and 22. There was a case called Johnson versus Wisconsin Elections Commission. That was the first of the redistricting cases this decade. There was no, in those cases, the Wisconsin State Supreme Court, which was the court that we were litigating that in front of, they refused to consider partisanship as they were looking at the districts. And they said, and this is both for state and congressional districts, they said, number one, we're not going to consider partisanship at all. And number two, they demanded that the districts be ones that made the least changes from the 2011 districts. As we all know, those were extreme Republican partisan gerrymanders. As a result of that, what we got in the spring of 2022 were districts from the Wisconsin Supreme Court, congressional districts that were a very heavy Republican gerrymander, and state legislative districts that were a very heavy Republican gerrymander as well. Fast forward a little bit to August of 2023, the balance of the state Supreme Court had changed. We brought another case called Clark versus Wisconsin Elections Commission. That was directed solely against the state legislative districts, okay? Congressional districts not involved at all. We succeeded in that case in having the court basically reverse what they had done in the Johnson case and say, for state legislative districts, when courts are adopting new districts, they have to take into account partisanship. And they were not going to follow a least changes rule. And as a result of that, the parties to that, and there were 7 different parties, the parties all submitted proposed districts. Speaker Voss, who you can say what you want about, but he's a very savvy politician. And he knew that if the court selected from among the districts, he might choose the districts that we had drawn, or our group had drawn, or one of the other groups that were going to be more favorable to the Democrats. Ironically, the governor's proposed districts are the ones that were the most favorable to the Republicans, at least of the ones that were really in play. And so Voss, being the savvy politician that he is, he said in February of 2024, I think we're going to adopt the governor's state legislative districts. The governor agreed. They were his maps, after all. And so that got done legislatively. And as a result of that, we can see how the districts changed. We can see the composition of the assembly, how much it changed. The Senate changed a little bit too, and it's going to change a lot more this fall. And Democrats are likely to take control of it with the new districts. And there's a shot at the assembly as well. So we got much fairer state legislative districts, but that left the congressional districts with the Republican partisan gerrymander that they'd had since 2022. So some of the lawyers, and there's a law firm called the Elias Law Group. Many of you have probably heard of Mark Elias before. They represent partisan Democrats. And as soon as the state Supreme Court issued its opinion in the Clark case with respect to state legislative districts, Elias Law Group came into the state Supreme Court and they said, hey, time out here. You just apply this rule to the state legislative districts. We want you to apply it also to the congressional districts. And the state Supreme Court didn't take that up. They said, nope, we're not going to take it up. We're not going to do it. So then last year, in May 2025, the Elias Law Group again filed another case, and this is what's called an original action petition. So they filed this with the state Supreme Court. Didn't go to the circuit court first, went right to the state Supreme Court, and they tried again. And they said, hey, we would like to bring an original action asking you to hold that the congressional districts are a partisan gerrymander that violates separation of powers doctrine, several of the provisions of the state constitution. And again, the state Supreme Court said, nope, we aren't going to hear it. And so when the state Supreme Court turns it down that many times, your only recourse then is to go to the circuit courts. And so that's exactly what both we did. Our group, we're working with the Election Law Clinic at Harvard Law School. This is Ruth Greenwood and Nick Stephanopoulos, who I've been working with since the Whitford case 11 years ago. And they had been our co-counsel in the Clark case as well. We filed what's called an anti-competitive gerrymandering claim against the state congressional districts. Everybody's familiar with partisan gerrymandering claims. You know what those are, right? That's where a political party has control of the legislature and they draw districts to benefit their own political party. There's also a racial gerrymander. And a racial gerrymander is when the legislature will draw districts to pack Black or Latino voters typically into districts, right? So many more Black or Latino voters in that district that are necessary to actually elect a candidate of their choosing, which dilutes their right to vote. And then they crack them in other districts. They spread them so thinly that they can't possibly get a majority, right? So that's racial gerrymandering. So what we brought, though, is an anti-competitive gerrymander. And our theory, which has never been brought before in Wisconsin, was that the parties, the representatives of the parties back in 2011 had essentially gotten together and kind of divvied up the congressional districts. Certainly the Democrats did not want to agree to districts that were going to give the Republicans a majority, but they weren't in control, right? They didn't have control. They had no power. And so basically what ends up happening is you get agreements where districts are fixed. It basically is incumbent protection. And there was an agreement essentially to make certain districts safe districts for Republicans and certain ones safe for Democrats. Well, who does that harm? That harms the voters, right? Because as we look at the decade after 2011, when they went into effect, or 12 or 13 years after they went into effect, we see that in those districts, they're being won by 20 percentage points, 30 percentage points. They simply aren't competitive. And so we brought an anti-competitive gerrymandering claim. A week after we brought our claim, the Elias Law Group filed a partisan gerrymandering claim against the congressional districts as well. We filed that in Dane. We filed both of our cases in Dane County Circuit Court, and the state Supreme Court appointed a panel of 3 circuit court judges from other counties in Wisconsin to hear those cases. We briefed these motions to dismiss, and just this spring, on March 31st, the Elias Law Group's complaint got dismissed. Our complaint got dismissed last week. Elias Law Group hasn't appealed to the state Supreme Court yet. Maybe they will, maybe they won't, but we have appealed ours and we've asked the court to hear it very quickly. They haven't ruled on that motion yet, so we don't know. But that's up in front of the state Supreme Court right now. So basically, though, so far, the state Supreme Court has successfully avoided answering the question of whether partisan gerrymandering is permitted when drawing congressional districts, or whether it's something that parties that the legislature can't do. So that's where we are on the state front. You want me to go ahead and pivot to the Voting Rights Act case?
Please, thank you.
Yeah, okay. So last week, many of you probably heard there was, you probably read the book a long time ago. What was it? Alexander and the Terrible, Horrible, Very Bad Day. I can't remember it now. I probably read it 50 years ago. Carlene knows what I'm talking about. Yeah, anyways. Well, that was the Horrible, Terrible, Very Bad, No Good decision that was authored by Justice Alito last week in Louisiana versus Callais. And this was essentially the coup de grace that was, thank you, Mary Beth. That was essentially the coup de grace to Section 2 of the Voting Rights Act, um, uh, being able to bring claims. I'm gonna back up just for a second to 2013. People might remember the U.S. Supreme Court decided a case that year called Holder versus Shelby County. That was a lawsuit that was brought by former Attorney General Eric Holder against Shelby County, Alabama. I can't remember if that's what it was, or Mississippi. Anyways, one of the southern states. That involved Section 5 of the Voting Rights Act. As you all will recall, in 1965, Congress adopted and President Lyndon Johnson signed the Voting Rights Act. That's because despite the passage of almost 100 years since emancipation, there were no Black representatives in the United States Congress, none. With the horrible violence that was wreaked on John Lewis and others, that brought to the national attention what was going on in the South. So the Voting Rights Act passed, and the whole point of it was to try to get communities of color, Black communities, and more recently Latino communities, actual representation and power in the United States Congress. Right? That's what it's all about, having power and a voice in Congress. It was very successful over the years. It was enacted in 1965. In 1980, the U.S. Supreme Court decided a case, and it held that the Voting Rights Act only covered intentional discrimination, right? So only if you could show as a plaintiff in a case that, there we go, thank you, Alabama. Only if you could show that the legislature intended to discriminate against Black or Latino or minority voters, that you could have a cause of action. Well, Congress didn't like that. The United States Congress was very different back then than it is now. And in 1982, the Congress amended the Voting Rights Act to say that Section 2 doesn't preclude or doesn't prevent only intentional discrimination. It also prohibits discrimination in effect. And so the U.S. Supreme Court, in a case in 1986 called Jingles, adopted a standard to evaluate Voting Rights Act claims under Section 2 that has been in place since 1986. For 40 years, it's been in place. And we've litigated a lot of cases under Jingles. I won a Section 2 Voting Rights Act case under Jingles in 2012 in the Eastern District of Wisconsin, where we got two of the Latino Opportunity Districts in Milwaukee redrawn. That's the framework that was in place. But very famously, John Roberts has been an opponent of the Voting Rights Act since the day he was a young lawyer in the United States Department of Justice's Civil Rights Division. Yes, you heard me right. John Roberts was a lawyer in the Civil Rights Division in the Deep South, and he's always opposed the Voting Rights Act. He's disliked it. He's wanted to dismantle it. And in 2013, in the Shelby County case, he got his first chance to do that. That case involved Section 5 of the Voting Rights Act. That was a pre-clearance case. Under Section 5, these states that had historically discriminated against Black voters, Section 5 required that they actually have to get their districts cleared by the United States Department of Justice before they could go into effect because of that past discrimination. Well, basically, Roberts wrote an opinion that said discrimination, it's a thing of the past. Look at all this progress that we've made. And there was tremendous progress that was made after 1965 because of the Voting Rights Act, right? When you put legislation in place that actually requires districts to be drawn in a way that doesn't discriminate unfairly against Black voters, Latino voters, Native American voters, you actually make progress. And they made tremendous progress. There was a lot of progress. And Roberts basically said, well, problem solved. Racism, a thing of the past, it's done. And so they didn't eliminate Section 5. They didn't hold it was unconstitutional, but instead they changed the formula. They held the formula was illegal. And as a result of that, the formula just couldn't be applied. And since then, basically Section 5 hasn't been enforced. There have been no pre-clearances since that time, at least that I know of. That was Section 5. And one of the things that Roberts said in that opinion was, well, Sure, Section 5 might not have the teeth that it once had, but there's always Section 2 of the Voting Rights Act. And so if minority voters are being discriminated against in the representation, you could bring a Section 2 claim, right? So now let's fast forward to what happened last week in this Callais decision. So in that decision, and it was written by Justice Alito, he served as the hatchet man, Roberts didn't have to. In that case, Alito said, well, they didn't get rid of Section 2, much like with Section 5, they left Section 2 kind of intact and didn't hold it was unconstitutional. But basically, they said Section 2, over the years, when you draw districts based on race, you have to have what's called a compelling state interest. That's been the law forever. You have to show there's a compelling state interest. And the US Supreme Court had always assumed, they'd never decided, but they always assumed that compliance with Section 2 of the Voting Rights Act supplied that compelling interest that state legislators needed to be able to draw majority Black, majority Latino districts. And Alito said, well, we're going to look at that now. We're not going to just assume it. We're actually going to take a look at it and see if it provides a compelling state interest. And what they ended up holding was it does provide a compelling state interest when Section 2 is, quote unquote, properly applied, right? Uh-oh. When you see that it properly applied in italics, you know something's coming. And so then they moved on to say, what's the proper application of Section 2? And they basically said Section 2 properly applied in the context of redistricting today means that you have to, number one, let me back up and give you one other piece of information first. They looked at partisanship. They looked at the usual criteria that state legislatures look at when they're redistricting. They said these are the things that they usually look at, the things that are acceptable. These traditional redistricting criteria. And remember, I said before, back in this Rucho versus Common Cause case, Chief Justice Roberts had said, and the majority of the court said, partisan gerrymandering, bad, bad, bad. But we can't do anything about it. What Alito said in this case last week is partisan gerrymandering, hey, it's just another traditional redistricting criteria. It's a completely legitimate state aim. And states can do that if they want. Partisan gerrymander, your heart's content. It's totally fine, right? That's what they said. So what does the proper application of Section 2 mean now? Well, according to Alito and the majority of the court, it's not just on him, it's on 5 other justices as well. You can't use race as a consideration when you're trying to draw or when you're trying to determine whether this is a Section 2 violation. Because race can't be a consideration when you're drawing districts. That would trigger strict scrutiny. And so what you have to show, if you want to prove a Section 2 claim, the way we prove these claims, even before the decision last week, is we would, if we looked at a district and we said, hey, this district violates Section 2, the way that we would prove that, and there's a very, very complex way of proving it under the Jingle standard, but basically it boils down to this. We would draw a lot of districts through algorithms, okay? We'd get experts who would draw thousands and thousands of maps, and we'd say, look at all these maps. In all these maps, we're complying with the traditional redistricting criteria, which the legislatures would have to do. But look, 99% of the maps that we drew that we're showing you, we could get more Black or Latino majority districts or opportunity districts than you came up with, okay? And that's how we could show a violation of Section 2. So Alito says, well, we're not going to change that the way that you prove it, but what we're going to do is when you have your proposed districts that you say are going to show a violation of Section 2, number one, you have to draw those districts without controlling for race. In other words, you've got to prove essentially a claim of racial discrimination, but you can't use race to prove it, right? Doesn't sound right, does it? And it's not. And number two, and this is the real trick here, this is where he really pulled the ace out from under his sleeve. And also, because your districts, your proposed districts, have to comply with all the traditional redistricting criteria, and partisanship is one of those criteria, you basically have to show that the majority Black or majority Latino district that you're drawing would have had the same partisan skew essentially as the district's legislature drew. What that means is, let's just take a hypothetical example. Let's say you've got a district, let's say, we'll just use Republicans because why not? Let's say Republicans that drew districts in Wisconsin drew a district around Milwaukee, and we challenged that in a lawsuit under Section 2 of the Voting Rights Act. And we said that, yeah, we've drawn this district here. We can draw districts where there is a black majority district. And the legislature says, aha, but we drew that district to favor Republicans. We didn't draw it with respect to race. We drew it to favor Republicans because race and voting preference, party preference, are closely correlated for black voters, very closely correlated. They're correlated for Latino voters as well, but not quite as strongly. Because of that, essentially the upshot is we would have to show that you could draw a district where the majority of black voters are voting for Republicans. So the bottom line, sort of the upshot of this opinion is, as applied to the way things are in the United States right now, maybe they'll change at some point in the future, but the way that they are right now, and you can see this by all of the southern states now that are redrawing their districts, right? Any of these plaintiffs now, if they want to challenge those new districts, are basically going to have to show that if you want to draw a black majority district, those districts would have to vote for Republicans instead of Democrats. And so really what they've done is they've really kind of eviscerated, they've left Section 2, it's on the books, but they've basically eviscerated it. And so you've got the racial components of this, which are just horrible, because we're going to see the number of black representatives from the Deep South and Latino representatives probably from states like Texas and Florida probably decline, probably significantly. That's what many of the experts are predicting. But the other part of it is the partisanship piece of it as well, which is really horrific. We've gone from this regime where the US Supreme Court said partisan gerrymandering is bad, but we can't do anything about it, to now saying, hey, this is a legitimate state interest. States can do this. And so basically what this does is it allows states where you've got complete party control by one party to partisan gerrymander and to hide a racial gerrymander behind it. They can basically mask a racial gerrymander with a partisan gerrymander, and it would be almost impossible to prove. So what is the fix to this, right? What is the antidote to this? And, my thought on this is that the only real antidote to it, and this is where you all come in, is if we can put a lid on partisan gerrymandering, if we can end partisan gerrymandering, if we can make it illegal, take away the right of a legislature in Wisconsin to engage in partisan gerrymandering, we can take away their ability to mask a racial gerrymander and disenfranchise, disempower, or dilute the voting power of communities of black voters or communities of Latino voters. So that's what I think the upshot of it is. But I've been talking for a while here. Let me stop.
Thanks, Doug. I got really emotional because it sucks. And I got emotional because one, I got really sad, and then you gave us a little bit of hope, a glimmer of hope towards the end. So thank you for that. Earlier, one of the questions that folks had was, what would the effect of something like that look like in Wisconsin in particular, given that we have really hyper local cities that do have more minorities in comparison to states down south?
Yeah, so if you might have seen some of the media that different people did around the Callais decision last week, and one of the things that I know Dan Lennington from Wisconsin Institute of Law and Liberty was saying was, well, this poses a problem for some of the aldermanic districts in Milwaukee, which were deliberately designed to empower black voters in Milwaukee. Number one, that isn't a new question or a new legal issue. That would be a 14th Amendment issue, which has always been an issue anyways. And so that's really not impacted by this particular ruling. I don't know of, I will admit, I haven't kept my finger closely on the pulse of the districts in Milwaukee and who drew them and how they were drawn and why they were drawn, if they were using Section 2 of the Voting Rights Act to justify drawing them or not. But, you've always had the ability to be able to challenge those. So I don't think that that's anything new. But yeah, it's a 14th Amendment issue. There's no question that the federal courts are scrutinizing that more heavily than they ever have before. That's sort of been the evolution of things over the last 15 to 20 years. And so designing districts specifically with race in mind is something that the US Supreme Court has said is you can't do, it's forbidden. Or you've got I shouldn't say it's forbidden. You go through strict scrutiny analysis, which means you've got to have a really heightened justification, show that compelling state interest for the reason why you're doing it. So I think that the you've got areas like Milwaukee. If we look at the city of Milwaukee itself, and again, I don't district in Milwaukee, the automatic district, so I don't know exactly how it plays out, how easy or difficult it is when you're drawing those districts. But I would imagine because Milwaukee is so there's such a large Black and Latino populations there. Combined, it's a majority of the population of the city demographically. It my guess is that there are you would naturally you could district there and district majority Black districts, majority Latino districts without doing it intentionally based on race, right? Because one of the things we can look at are communities of interest. And that's what came up in our 2011 case, in the Baldus case, where we had the Latino districts. The legislature basically divided, they had drawn one big district, or two districts, I'm sorry, and they basically divided it, put the dividing line right down the heart of the Latino community. And they just divided that community in half. And we were able to say, well, you've just cleaved a community of interest in two here. So,
Yeah.
but that will be an issue. That will be an issue. And I think that groups like Will are going to jump on those kinds of things. It's probably more, it's I don't know, how much that's going to impact things in Milwaukee.
Mhm.
They're going to get a lot more juice if they can make hay out of state legislative districts or Senate districts or congressional districts. But I just don't think we have the numbers there to really have Section 2 have much of an effect statewide in Wisconsin at this point.
Thanks, Doug. We did have a question in the chat that I might need more clarification on because I'm not sure what the Governor's Evers wording was, but I'm going to read it anyway. So, could Congress consider legislation for congressional seats that would use similar wording to Governor Evers' wording, which only covers the state legislature?
The United States Congress could absolutely pass legislation. You'd have to have, at this point, you'd have to have a veto-proof majority in Congress because the president can veto it. But the United States Congress could absolutely they could revamp the Voting Rights Act, and they could put language in that would basically plug the holes that Justice Alito kind of ripped open in it. And they could make it clearer as to what they intend and what they want. So you could absolutely have that happen. That's something that they could fix.
Okay. Um, Thank you so much. One of my favorite fun facts is that every 30 seconds, a Latino in the US turns 18. So it just makes me wonder if this is why they're challenging this, is that we are the new majority before 2050. So it's exciting to see folks in the fight for the long run, right? All we've got is to shoot to that North Star. So thank you so much, Doug, for your time. And I'm sure more questions will come up, and I'll do my best to follow up via email if any more do come up. Thanks.
I'm always happy to join you and happy to talk and keep fighting the good fight. Thanks to all of you for the work that you're doing.
Thanks, Doug.